Any tips and tricks that you guys know?
It was a great presentation, Carol.
Thank
Truly,
you.
really.
Thank you.
All
Thank you.
right. Well, if you have anything else to wrap up, please do so. But if not, I mean, let's all, yeah, I just all make some comments or maybe react to such a fantastic presentation. We really appreciate everything, Carol, and I'm sure everybody pleased to know that I'm going to be passing along handouts that in your PowerPoint that you used for reference. And I really encourage you. I've known Carol for many, many years, and over the years, while it doesn't come up very often, it's great to have her as a resource. I've referred many people to her, all of which have been very pleased, and I've consulted with her on occasion as well over the years on various matters. So, especially if you do, if you do estate planning, if you do some, guardianships, conservatorships, all those types of activities, Carol is a great resource to have, and we hope she'll come back again, in the future and present as well. So, okay. All right. So
Thank
if that's
you.
everything, thank you, Carol. So we're going to move on to the next presentation, which is really the last two are going to be done by myself. And we'll have the last verification word after we're all done, but we've got two presentations left. The first one that I'm going to do is on probate related document preparation. And then the last one will be on ethics, although I would say that Carol's last presentation covered ethics as well, but we've got that planned as well. So we will move on. Give me a moment to set this up and we'll go from there. Okay. All right. Can I get a thumbs up from anybody that you can see the presentation? Everything's set up correctly? Or maybe a shaken head? Thank you very much. All right. So we're going to start off by talking about probate related document preparation. And just before I get into those issues, also as just to let you know my background, I've been a certified legal document preparer since the inception of the program, and for about 10 years prior to that, I was also what we called ourselves independent paralegals, and I've done a lot of probate related services. Oh, Bernie, you're saying you only see me, so let's see. Richard Hoyt, I see you. Can you see the presentation, the PowerPoint? Yes? Okay. All right. And I got that from Carol. All right. So as I was saying, I've been doing probate probably since the mid 1990s. And while there have certainly been some changes, it's been mostly the same type of procedure for probate and probate related processes. I don't it's not a major part of my business anymore, but I certainly continue. Check to see if, oh, okay. But I'm sorry, I'm seeing messages on the screen. I certainly, probably every couple months, I'm still doing some type of probate process for somebody, some of the processes that we'll be going over today. Now, one of our main goals with these continuing legal education webinars or seminars is to try to encourage our members, try to encourage the people that are attending the webinars and seminars to maybe consider expanding services and based upon at least a kind of a jumping off point from some of the people that are presenting at our seminars. I've got a quote up on the screen, but in the world, nothing can be said to be certain except death and taxes. That applies to, the current topic in probate related matters. It's a huge and ever-present market for legal document preparers to practice in. And today I'm going to introduce you to some of those services, those probate-related services, and how you may want to approach providing those services. So what we're going to talk about today, the course overview, we're going to briefly touch on in kind of an overview of estate planning, which Carol went over that, and I know many of you are provide those types of services. We're going to talk about a definition for probate. We're going to talk about determining a customer's needs, how you engage in those conversations, maybe over the phone and or in person. And then we're going to talk about ways to maybe circumvent probate, their probate related processes, utilizing when it's appropriate to use small estate transfer affidavits for personal property items, for real estate items. And then we'll get into talking about the probate process. And where you have circumstances where the probate process or the informal probate process works or doesn't work. We'll talk about formal probate and also some other special circumstances. So let's start off with estate planning, and really, as I said, before we get into a review of the probate related documents, I just want to kind of briefly comment on how people end up in the probate process. To put it simply, certainly, as many of you are aware, probate can be avoided by simply engaging in some types of, what I view as mostly simple estate planning strategies to avoid that, such as direct beneficiary designations. As most of you or many of you are probably aware, having a direct beneficiary designated on your insurance policy, your retirement plan, your savings account, bank account, brokerage account. These are all ways to circumvent the necessity for probate. You can name whoever you want to receive these assets, these accounts as a direct beneficiary, and you don't have these issues. Your client doesn't have these issues. Other ways, owning things in joint tenancy with the right of survivorship, having beneficiary deeds, and then what probably many of you recommend for your clients, having a trust, a living trust to organize an estate and create a situation where probate issues don't come about. Of course, even taking, those actions, having what you believe are safeguards in place, there can be situations even with trusts where probate becomes a necessity, which is a reason that we do pour-over wills, for example, so that if there's something unforeseen, you either by accident, an account, for example, didn't get put into a trust, or someone dies in a circumstance where their estate may have a claim, like a traffic accident or something like that, that may necessitate doing some type of a probate action in order to pursue those claims. But so what we're talking about today is for circumstances where you have clients that have not engaged, at least not engaged adequately, or maybe had some unforeseen circumstance that came up that necessitated that left an asset or a claim or account or personal property that was not dealt with by direct beneficiary designation, not dealt with in a trust, so on and so on. All right, so let's start to talk about what probate is. And here's, my definition for a probate. Probate is a process by which the property left by a deceased person is handed over to his or her heirs, devisees, or beneficiaries. And this process may include proving a will if there is one, appointing a personal representative, and generally speaking, settling an estate. So, before we get into, talking about the specifics, let's talk about how we size up the situation. Like, we have a client that calls or shows up at our office that seems to have some type of probate related needs. How do we really determine what those needs are. What questions are we going to want to ask, either directly or through some type of a questionnaire? And, and I have, kind of a list of things that you may want to consider, in developing maybe a script or just a hierarchy of questions that you'll ask to determine and whittle down to what a customer will actually need. Of course, the first kind of question or consideration is whether probate's necessary at all. I have in my practice over the years had many circumstances that came up where, somebody came to me and, believed they had a probate matter, and where there didn't end up being a probate matter at all because they either didn't understand what was going on with a particular asset or with a particular estate, or they're just completely unaware of it. For example, I've had people come to me to say, yeah, my father died, and there's a house and we need to sell the house, and so there's no will, and I need to open probate to do that. And through some questioning or maybe a little simple investigation, I discovered, in fact, there was a beneficiary deed, or there was, directly, um, which would directly transfer the property over to that person. Um, that's just an example. Or, people aren't aware a lot of times that, bank accounts, brokerage accounts, they're not even aware that you can do direct beneficiary designations. And so people think they need to engage in some kind of informal probate or probate related matter in order to deal with those assets. So we want to determine, is this a probate related matter? If so, can the estate, asset be transferred utilizing maybe some systems to circumvent the probate process, like small state transfer affidavits, or is an informal or probate or a formal probate going to be necessary? So other, important questions we're going to want to ask, is the asset a personal property or real property? And that's going to help us determine, maybe the type of procedure that we engage in, whether it be, again, small state transfer affidavit for personal property or for real property, whether we're going to have to go to court, as part of that process. We want to investigate or ask questions about how the asset is titled. So is it solely in the decedent's name? Are other people on there? How did they hold title? Is it in joint tenancy with the right of survivorship? Is it tenants in common? Is it in community property? Ask for copies of the property deeds or look them up yourself. In Arizona, as many of you may be aware, it's a pretty simple thing to look up the title to a property. I always, and this is probably not great, not unknown insight, but I usually go about doing that by going through the assessor's office first in Maricopa County, at least, because they're going to usually have tagged to the assessor's information the most current title. And so, yeah, I think you're more likely to find the accurate title by starting there. So again, is the property title in joint tenancy or community property? Is there a beneficiary deed? So you're looking to determine the necessity of this, whether you can do a small state transfer or probate. Also, you're wanting to know, you may be wanting to determine if there are some special circumstances where it might be maybe beneficial to do a joint probate. So for example, sometimes on occasion, I have had parties come to me where both their parents have passed away, and they held title to real estate for whatever reason as tenants in common, and so we ended up doing some kind of a joint probate for both the deceased, and I'll talk about that more a little later. The other reason that you want to go into all these questions too is that it may pose an opportunity to offer other services for these same clients, as you go through, as you help them with this process, like additional deed preparation, additional estate planning for those people. You have a surviving spouse, or you have children, or a child that may need a similar service, so they don't have to go through, or their heirs don't have to go through the same type of issue when something happens to them. Other important questions: what's the value of the asset? That's important in determining whether we can use small state transfer affidavits, or if we have to go for an informal probate or probate. Where is the asset? That speaks to jurisdictional issues. Where are they going to have to, for example, if you have to do a small state transfer affidavit for real estate, that's going to need to be done in the county where the property is located. Or if you have a circumstance, for example, that a probate's maybe been filed in a different state, and you're wanting to, the customer is looking to get the authority in Arizona to deal with a particular asset, where that proof of authority would be filed, what county. Again, I'll talk about that more specifics as we go through this presentation. What's the client's relationship to the decedent? So do they have standing to be a personal representative? Are they somebody, especially if there's no will, are they somebody, according to intestate laws, that is going to be in the succession of who the heirs could potentially be or not? Especially in this day and age where you have people that have been together many times for many, many years, that aren't married, aren't really blood related. There may be problems with them being able to inherit the assets or left by the deceased person. Stepchildren, for example, or again, significant others that aren't married. These can pose these can be significant problems or issues that have to be dealt with, and that may trigger you to refer them to an attorney for advice on how to deal with the problem. Where did the decedent die? We talked about that just a minute ago. Jurisdictional issue again. Other questions: who's entitled to the assets and why? Is there a will? Who are the surviving relatives? Are the whereabouts of relatives and interested parties known? Again, that can end up to be very problematic with dealing with assets if somebody, for example, named in a will to inherit assets is missing in action, or as I mentioned a little while ago, if there's no will, if there are people that it seems were intended to inherit certain assets but really have no legal standing to inherit them, at least it appears that way. Are relatives and interested party cooperative and in agreement? So especially when you have an intestate situation where there's no will, does everybody agree who the personal representative should be named? Does everybody agree about how the assets are going to be divvied up or divided? I have many stories I could tell you about situations where everybody kind of assumed everything was in agreement, but one or more of the potential heirs, the children usually, have different stories about oh, mom said that I should get this, or dad said that Junior should get dad's car that he always drove. So these are not things that are documented. There's no will, and they can cause big problems between heirs when you're trying to probate or deal with distribution of an estate. Is anybody waiving their rights to estate property? I'll talk more about that issue in a moment. So again, all these issues determine on the type of probate, if we can do a small state transfer affidavit, if we can do an informal probate, or if we're going to have to go formal. When did the decedent die? Is this something that just happened yesterday? Did it happen, last year, or did it happen 10 years ago and nobody's dealt with anything? I see many situations where for whatever reason, people just never had a need to take care of something. So for example, real estate only in mom's name. Mom died 15 years ago, but everybody just continued to live in the house. And so, or just other situations, especially if people don't have the resources or time to deal with an informal probate, a formal probate, or if they can use a small state transfer affidavit, can they wait the time period that's necessary before they can do that? The bottom line is, when the decedent dies, will determine what action that you could potentially take, whether it be a small state transfer affidavit, whether you can do an informal probate, or if there's some kind of an emergency going on, if you can do some kind of a special administration of the estate and then open an informal probate later. Again, we'll talk about those a little more as later in the presentation. Or if it's been a long time and you're doing a specific type of probate action, is it past the time where you can do that? It's something called a tardy probate, and what are the consequences of that? When does the customer need the assets transferred? That's related matter I really mentioned. Urgency can impact the customer's choice to file a small state transfer or informal probate. So put it simply, you'll see this in the documents as we review them. A small state transfer affidavit, if it can be used to transfer real estate, for example, cannot be filed any sooner than 6 months from the date the person died, the decedent died. And so if somebody needs that done quicker, needs to sell the house quicker, for example, then they may opt to just open an informal probate so they can do it quicker, where you only have to wait a certain number of hours from the date of death. So let's start to get into the specific forms that can be used, starting with the transfer of estate property by affidavit, personal property, that is. So any type of personal property, and that includes financial accounts, bank accounts, checking accounts, brokerage accounts. You can use an affidavit like this to transfer those assets to whoever the rightful heir is. That would also include vehicles, for example. So what are the requirements? Value of all the personal property items of the estate shall not exceed $75,000. At least 30 days shall have passed since the death of the decedent. And the client would then be entitled to the personal property, have the rights to submit an affidavit claiming the property. And that would be so because the client is named in a will to receive the property, or if there is no will, the person would need to be the surviving spouse, a child when there is no surviving spouse, or there is, but he or she is not the client's parent, and the client's other parent, the decedent, a parent if there is no surviving spouse or child, a brother or sister if there is no surviving spouse, child, or parent. The other consideration is that, let's say that there are multiple people that are entitled to inherit some asset, and we can use a small state transfer affidavit. Let's say there's 3 kids, for example, but somebody, one or more of the children, don't want to waive the rights to the asset. So that can happen by them signing an affidavit that's attached, waiving the rights that's attached to the main affidavit. So let's talk about how these things are processed and take a look at the affidavits. So simply speaking, after it's prepared, the affidavit is simply presented to whoever has the personal property. And the effect of is that the person paying over or delivering the personal property to the person presenting the affidavit is released to the same extent as if he or she was dealing with the decedent or a personal representative of the decedent. So we're going to take a look at a sample affidavit. And let's see, I'll look at I know there's a couple questions. Um, let's see, Susie, I think Susie's asking, I'm finding that banks are asking for letters for bank accounts or financial accounts. Have you encountered that? Our probate clerk in Yavapai County is finding that this is getting more prominent. In my experience, I find that a lot of people at the branch level are very uninformed about what they need or what they don't need, and have to kind of pass that up the chain of the command or to legal. But they absolutely can release it using a small state transfer affidavit. Again, if the assets are under $75,000 in value. But yeah, that what you're describing is something that is very common that it's not uncommon, I should say. However, I've helped I've helped many people with these kinds of issues, and if you often I will include with the affidavit a letter that gives a little bit more of a description about what's going on and why they can do this. Most of the time I do not have people come back and say, yeah, they didn't know what I was talking about, or they said I needed testamentary letters. But it is definitely a problem that and it's mostly because they're ill-informed. I don't think it's because they're trying to CYA. I usually when they call legal department or they'll or email their legal department, the legal department will look at it and tell them that it's okay. Diane is asking, or they send out a blanket letter that says they need letters. Okay, same kind of thing. Hopefully that answers your question. I mean, if that's what they're requiring, I guess sometimes you might be forced into it. But I've never had anybody that ultimately had to open probate simply because the person at the branch level did not understand that they could legally hand over the money. Yeah, Susan is asking, is the $75,000 limit per asset or total of all assets? My understanding that would be a total of all their assets. Okay, so let's let's take a quick look, and I want to show you these things, for two reasons. One, so you see them, but also I'm trying to some extent, I guess, highlight the simplicity of a lot of these documents. Can you all see the affidavit for collection of personal property? Is that up right now? If someone would respond? Yeah, okay. All right, so as you can see, this is a pretty simple document. Um, uh, you're just giving your information, your name and address. You're typing in who the person is that died, their date of death, their place of death. You're stating, you're attesting that the 30-day requirement has been met. You're talking about your relationship, the value of personal property. Yeah, it is the $75,000 is the value of all personal property in the estate. The that there's no personal representative that's been appointed. Um, I think also, even if, I mean, I've had some circumstances where maybe a probate was opened in a different state and it's been closed. But for the most part, you're stating that no personal representative has been appointed, and here's a list of the circumstances where your client may be entitled to claim the asset, whatever that may be, the personal property asset. So I'm named in the will, and you want to put a copy of the will. The deceased had no will, but I'm entitled because I'm the spouse, I'm the child, I'm the parent. I'm the brother or sister where there's no spouse or child or parent, or just a statement the person died without a will and I am the sole heir. So you check all the boxes that apply. When I was talking about how sometimes beneficiaries with an equal right to whatever's there will agree that one or two of however many people there are going to actually get those assets. So you will need the people that are waiving their rights to sign a document saying that they're waiving their rights. So the person died and left a valid will. and people of equal or greater value than I have to the property have all assigned their interest to me. I'm going to show you what an affidavit could look like of that sort. And then you list the person who died owned the following personal property. So you can use one affidavit for multiple items. And I see there's a couple other comments in the chat. Personal property 75,000 excludes any beneficiary designation like retirement. Yes. Or those thresholds, and are those thresholds inclusive of each other, or is the 70 or is it $75,000 financial assets and additional 100K in real estate? Yeah, they're separate. And then so you list whatever assets are being transferred through this. And then you also list, the person who died was entitled to collection of the following debts from people located in Arizona. So you would, list any applicable debts that were owed to that person. So that can all be included in this. So that's a sample of the affidavit. As you can see, it's a pretty simple thing. However, I've done probably, a couple hundred of these over the last 15 years. It's not a big part of my business, but it's something that's easy to do and is very helpful for people. People often do not feel comfortable. They don't understand the process. They don't feel comfortable doing it. So that's one. Let's look at, I also wanted to show you a waiver, sample waiver. So this is something I'm sure I used at some point as a sample, just saying, I'm the beneficiary of the person who died on such and such a date in Maricopa County, Arizona. And in this case, it references a last will and testament. This person is waiving any rights they have to a vehicle, and they're assigning their rights to one of the other people who's named it as a beneficiary in the will. So this is just something example. I'm going to send these examples to all of you too, along with your certificates of completion, so you can utilize these if you so choose to. Okay, so and then let's see, here's a letter that I have used in the past. So just explaining to whoever you're dealing with, in this case, it was to Bank of America. Enclosed, please find an affidavit for collection of personal property regarding the estate of Jeff Doe. This affidavit is made under Arizona laws section, and it cites the statute for the purpose of making a claim. And just asking that they issue payment of the balance of the fund in the above reference account to the person entitled to inherit it, and mail the same, to the address provided. So this is a little thing, but it can really be helpful in just directing them what to do. And also, so whoever is dealing with the matter on a branch level maybe knows how to ask and verify with their legal department that they can do this. Okay, that's all I want to show you for right now on that one. Okay, so to move along. Next one is transferring real estate by affidavit. So real property in the decedent's estate can be transferred by affidavit, which is located in Arizona, obviously, has an assessed value, less liens, encumbrances as of the date of the decedent's death. That can be a key factor, which does not exceed $100,000, and at least 6 months have passed. One of the things I failed to mention, which may have been obvious with the personal property affidavit, is obviously you need to give them a copy of the death certificate, a certified copy of the death certificate as well. So back to real property by affidavit, transfer real property by affidavit. So again, located in Arizona, the equity value is under 100,000 at the time of the decedent's death, and at least 6 months has passed since the date of death. The client is entitled to the real property or and has the legal right to submit the affidavit claiming the property, either because the person's named in the will to receive the property, or and in this affidavit, like the personal property one, it gives a list of, hierarchy of who's entitled to receive it, which would be the surviving spouse first, or a child if there is no spouse, or the parent if there's no spouse and child, or brother or sister if there's no, and there's a further hierarchy that we could go through. So Susie asked in the chat, on a tax bill, what value are you using? Our tax bills in Yavapai County no longer have assessed value. That's a great question. John Kroger, would you like to answer that question for us? I'll give you a minute to think about it and answer it as I go through the next slide. Oh, go ahead, John.
I'm pretty conservative, so because I'm trying to calculate basis for the resale of the property, I'm actually using fair market value via an appraisal. There may be attorneys that for the transfer situation will use an assessor's value. I'm more conservative than that. To use the assessor's value is aggressive because it's a significantly lower value, enabling you to transfer it. I generally use appraised value because I need that for tax purposes on the resale. Does that help?
Yeah, and I would do the same. That's what I would say. Okay. Okay, so let's see if there are, again, just like with the personal property affidavit, if there are people with equal or greater value than your client to the property, they can assign their rights to the entire estate to your client, which is proven by the copy of documents they signed to this effect that you attach to the affidavit. So let's see, other special circumstances, waiver of rights we just talked about, multiple applicants and affidavits, multiple properties. So with a real property affidavit, in the county, if the properties are in the county, you can name multiple properties on a single affidavit. And I don't think there's anything wrong with that. And the one financial benefit is that you would save multiple filing fees, as we'll get to in a second. Yeah, these have to be filed with the probate court. That is a way of saving, some filing fees. The only thing I'm uncomfortable with it is just that I just think it's a little cleaner to do them separately. But people do that all the time, and also after that's done, these people may be in a position where they're wanting to do further estate planning anyway, or just changing, the nature of the deed, adding their spouse to it, to the property they've just inherited, or just something else. And so I guess that kind of cleans it up, to some extent as well. So how do you process the affidavit? So the affidavit, which we'll look at a sample in a minute, it's prepared along with a cover sheet for probate court. If there is a will, you have to file the original will as well, and a certified copy of the death certificate. You take that all down, file it with the probate court. The probate court will provide you'll need to obtain a certified copy of the affidavit that's filed, and then you take that certified copy of the affidavit and you record that in the county where the property is located. And I'd be curious, any feedback on this. One thing that irritates me with these things is that years ago, when I used to file these, and I mean many years ago, we would get the certified copy of the death certificate back along with the certified document, and that's not the case. So I always, when I get the certified copy of the affidavit, I always get another certified copy of the death certificate to record with the with the county recorder. Now, I guess you could argue that if the certified copy of the death certificate that is filed with the court, that whole package together, stapled together, is certified, maybe you don't need to do that. But I always tell clients to bring me 2 certified copies of the death certificate so I can file the second one with the county recorder. And Mary Courtson is saying, I always warn my client that the court will keep the original. And Mary's bringing up another important point that can be disturbing for some clients, that the court keeps the original will. But she's saying, because you found that clients are surprised and dismayed, I just like giving them a heads up. That's good practice. I agree. So let's take a look at those affidavits. And I have a comment here that the effect of the affidavit, the purchaser of real property from or lender to the person or persons designated as successor in the affidavit is entitled to the same protection as a person purchasing from or lending to a distributee who has a deed of distribution from a personal representative. So it's, in other words, it's a valid deed. It's the same thing as if it was just deeded in some other way appropriately to that person. So let's take a look. Oh, I guess there's nobody there. Let's take a look at a sample, one of these affidavits. So the real property affidavit, again, these, and I don't think I mentioned this, you can get these off of the Maricopa County Superior Court website and probably other Superior Court websites in other counties. I'm pretty sure I've obtained them off the Pima County website as well, the Self-Help Center. But again, pretty simple information, everybody's name and address, the name of the decedent, the date of death, talking about where they died, or if they didn't die in Maricopa County, that there's property located in Maricopa County in this case, or if you're in another county in Arizona, you'd list that other county. Your relationship to the person who died. You have to put a description, the legal description of the property, which you can attach as an exhibit if it's lengthy. You have to state what the interest of the person who died had in there. So if if they owned, for example, if they only owned an undivided 50% interest in the property, you need to say that. Or if they owned 100% of it, you need to say that. You're saying the value of the asset, of the assessed value of the estate, of all the real property in the state, including any debt secured by a lien, is less the liens and encumbrances against the party as of the date of death does not exceed $100,000. So the equity is under $100,000. So you have $1 million house and the person owes $925,000, then you're okay to use this affidavit. There's this 6-month requirement, which often actually in my experience causes people to go ahead and do an informal probate because they can't wait or don't want to wait the 6 months from the date of death. But if you use this affidavit, you have to wait 6 months from the date of death in order to do so. And again, just like with the personal property affidavit, you're saying that no other personal representative has been appointed. Funeral expenses have been paid, and then you get into saying why you're entitled to this property. You're the spouse, or there's no spouse and you're a dependent child, or there's no spouse and we're dependents or minor children, or I'm named in the will, so all the same, basically the same reasons that we went over in the personal property affidavit. Whether or not, stating whether or not there was a will. You're saying that no federal or Arizona estate tax is due on the person who died in the estate, and then you sign it in front of a notary. If you have a situation, or everybody signs it who's signing it, so it can go into multiple people's names. If you have a situation where somebody is waiving their interest in the property, you would prepare a waiver similar to the one I showed about the personal property item. Although I don't think I have a sample of that in these things, but it's almost the same, except you're going to be referencing the real estate, and I always put in the legal description of a real estate in the waiver as well. Okay, so move on from there. Okay, so let's see. Bear with me for just a minute. So I'm going to start to talk about now informal probate. So generally speaking, an informal probate is a court process that allows a personal representative in an estate to transfer property of the person who died to the persons or entities who are supposed to receive it with kind of minimal court supervision. It usually does not require any type of a hearing. If this kind of probate is necessary, I would say it's probably the most common type of probate procedure or probate related procedure. It's overseen by a judge or the clerk of the court or a commissioner that's designated to oversee and administer informal probates. You can find the whole process kind of outlined in Arizona Revised Statutes 14-3301, and that includes describing the process of appointing the personal representative, proving the will. As we've kind of discussed already, in informal probate may be a testate informal probate where there is a will involved, and we'll talk about issues with a will in a moment. Or it could be an intestate situation where there is no will. There are definite differences between the two, and definite differences in the issues that can pop up. There are similar and different issues that can pop up between the two, the intestate or testate probate. Now, one issue, obviously, one of the first issues that has to be determined in any probate matter, an informal probate matter, is who is qualified to be the personal representative of the estate. So in other words, who's going to be in charge of that process of probating an estate. And that person, the personal representative, has many responsibilities, but as I said before, generally is responsible for administering and settling the estate. And that includes determining the assets and liabilities, safeguarding those assets, and distributing those assets as appropriate, and paying the bills of the estate, all in accordance with probate law. Now, the court requires training on that topic for any personal representative, and I'll show you where that's out in just in just a second. So who can apply to be the personal representative in a probate matter? This describes how you qualify. So you can be a surviving spouse, you can be an adult child of the decedent, a parent of the decedent, a brother or sister of the decedent, a person entitled to the property of the decedent, like through a will, for example. You can be a creditor if 45 days has gone by since the person died, or a public fiduciary. So let's look at briefly the training that's required. So this is something that it has to be done before the personal representative or the court will issue the actual authority through the testamentary letters for them to administer the estate. They have to complete this training, and there are two two videos or two packets of training that the personal representative or the person applying for personal representative has to go through. One of them, as we see on the screen, is an overview of serving as a non-licensed fiduciary, and the other is the personal representative training model. And just so they can watch a video, or they can go online and look at the PDF of the material, or you can print it out and give it to them. Ultimately, after they've completed that training, the person applying for personal representative is going to need to sign something just indicating that they've completed the training. And that's filed with the court along with all the other documents that we'll review in a minute. But just to kind of look at some of the stuff like the personal representative overview, just summarizes the role of the personal representative, kind of compares and contrasts supervised versus unsupervised probate administration if those are issues, explains how handling an intestate differs from an estate with a will, and discusses the process for finishing up, for closing the process of the estate. And I won't go through all this, but you can, I encourage you, if you're somebody that's going to start offering these services, I encourage you to kind of be familiar with these, watch the video, read the material, so you know exactly what your client is responsible for. But ultimately, it's the client's responsibility. And there's another document with all the probate forms in order to personal representative, which is similar to all this, that tells them what their responsibilities are as personal representative. We'll look at that stuff in a minute. Okay, so let's go back. All right. So these are the qualifications, the people that could be the personal representative. Other, off the bat, important considerations are, if there is a will, to kind of look at that will and also look at other issues or potential problems in a circumstance before you start filling out the paperwork, before your client, tries to apply to be appointed. So with the will, it's pretty simplistic, but you want to make sure that there are witnesses. There has to be 2 witnesses in Arizona to a will. You want to look to make sure that there's an attestation clause with the will that the witnesses signed. You want to make sure that there is a waiver of bond. Otherwise, your client's you may have to post some kind of a bond in order to administer the estate. You'd be surprised that there are wills out there that don't have a waiver of bond. And you want to make sure that the will hopefully names a personal representative. And, some issues that might be, present. Let me ask you all, for especially any of you that already do probates, what are some issues that can come up before filing and reviewing the will, and just other circumstances that some of you have seen? If you don't mind sharing some of those issues, or maybe a one or two issues that you have seen come up with probate related matters that you want to kind of head off, or at least be aware of before going all the trouble of preparing the documents. Anyone? International signers. Okay, Allison, I'd like to hear more about that sometime. Okay, Mary, go ahead and talk. You have something you want to say?
Yeah, I'm sorry. I started writing it and I thought, that's a lot. I did recently have a probate registrar that rejected the will that I had because the person who prepared the will, she was the notary, but she signed as a witness along with another witness. And so the document actually had the notary language in it, but for whatever reason, that notary signed as a witness. So I had 2 witnesses, but then it also said it was notarized. So long story short, my client decided we're not going to argue with the registrar we'll just treat it as if the will was not accurate.
So they pretended the will didn't exist?
Well, the registrar was saying it was not a valid will. And so I told the client, said, you've got a couple of choices, and, gave them, talk to the attorney. I said, you would have to go in then and request a formal probate to have the will authenticated.
Right.
Stating that it did have to sign witnesses and that, or we can give it to the probate registrar, have her make that determination, and that's what the client decided to do.
Okay. Yeah, that is crazy. I mean, I think that is a problem for the notary, but I mean, as you're probably aware, original will does not need to be notarized.
Correct.
So while that's problematic, I don't know why that would invalidate the will, as long as there were two witnesses. So
I agreed,
yeah.
except, yeah, so the notary signed the witness line as the notary.
Yeah.
But my information was that the notary can be a witness, is a witness. So if I notarized and had a witness, my understanding is then there are two witnesses.
Right.
Okay. All right.
Yeah.
They just didn't want to argue with it, and the family was all in accord with it. I told them, I said, that's totally up to you. I can't make any recommendation to you except, speak with an attorney if you'd like, deal with the probate registrar. So I just kind of backed out of that.
Right. Okay. Well, that is a problem. Thank you for sharing that. Patricia Glover says that she had a similar situation, but the registrar accepted it. But which I think is the right thing, even though there's an issue with the notary. But it's the notary's not, necessary. But
a little bit as a side note, I'm finding recently in the last couple of years, and for all of us to be aware of, there are notaries that are stepping up and acting as document preparers. And I recently had a deed that came across my desk where the notary actually prepared the deed, but it was prepared incorrectly. But the client said, oh, but she said she could do that. So I'm just doing that as a note. Maybe that's something we all want to take a look at and be aware of.
Yeah, definitely. And we'll talk about that in the final segment, maybe a little bit under ethics. But I guess John, I'll get to you in a second, but I just wanted to read a couple of these other things that are in the chat. Disagreements upon living heirs, certainly disagreements about, especially if there is no will, and they disagree on who should be the personal representative or who should get what. Multiple or co-personal representatives, not the original will, but looked like it. Yeah, and Brooke says she filed a original will, but the register said it wasn't an original. I've had that issue where sometimes it really is hard to tell. Even though you're 100% sure, I see the problem sometimes that the clerks deal with when it's just not crystal clear, and that's an unfortunate issue. But let's see. Ella was asking if the notary can also be a witness. No. Because well, I don't think so. I guess I could foresee a kind of a funky situation where the notary is notarizing the other witness signature, but not their own. But that seems a little funky. I would guess that that's not appropriate. And Allison cited unsigned wills, dead person, personal rep getting certified copies of death certificates. I mean, these are all, problematic issues. With a will problem, no witnesses, no attestation clause, not the original will, no personal representative named in a will, or the personal representative that is named is deceased. or there's no waiver of bond provision. These are all, potential problems, some of which actually have some solution. Like this happened to me once, and I want to say this may have been in the late 90s, or early 2000s when this happened. But I had a situation where there was no attestation clause. However, there were two witnesses, I at one time I had a good relationship with the registrar in Arizona. I don't even know if she was the actual registrar at that point, but and some of you that work in Maricopa County may know Meridel, and who is retired now. But she suggested that that I could do an attestation clause and have the witnesses, if I could find them, sign that now, and that in fact worked. So that was interesting, but it actually worked. I don't know if the other places would have treated it the same, but my understanding is that could be done. So, John, did you have something you wanted to say, or you lowered your hand? So, okay. So
No,
I
I'm
want to.
in, Don.
Okay. All right. So I'm going to, before we move on, I'm just going to take a quick peek for everybody. Like this is this typical will for George Washington. I bet you guys didn't know I had George Washington's will. But yeah, you've got a personal representative. In this case, George named Jimmy Fallon, which that's amazing to me. But and it has a no bond requirement. It deals with distributions. And I'm not going to go through all these things, but at the end it has an attestation clause and a place for both the witnesses, and which can also be notarized. So you just want to take a look at the will and make sure all those provisions are in fact there. And so I'm going to move on now and kind of go through the informal, the various documents that need to be prepared. So there's a cover sheet, application for informal probate, order to personal representative. I mentioned that kind of is a bit of a summary of the training. The testamentary letters and acceptance, that's basically, I don't know. I like, yeah, maybe this isn't the best description, but I've described it as kind of the power of attorney after death. That just authorizes the PR to do everything to administer the estate. The statement of appointment that's issued by the clerk, if necessary, if there's no will, or even if there is a will and there's not a waiver of bond, or maybe there's a personal representative name that doesn't want to do it, or that is deceased. And so or you just have an intestate situation where there's no will, you're always going to need the interested parties to sign a waiver of bond and a waiver and renunciation of their right to be appointed as personal representative. And then the certificate of completion of the training is also necessary. So we'll take a quick look at what those forms are like. And again, my purpose for showing you some of these forms is not necessarily to review them in detail. It's also to let you know kind of to some extent the simplicity of the document. So probate can obviously become very complicated, especially if it becomes a contested matter. But the basic forms are fairly simple and straightforward to fill out. So okay, so first I want to show you, this is the Maricopa County website. I have actually, in recent years, the last few years, I have just been using the court's forms. So the informal proceedings, you have all the forms from appointment through closing the probate, and it really gives you everything you need. The forms are really simple to fill out. And especially if you're just starting offering these types of services, I'd recommend you use the court forms. You know, at a time when I was doing a lot of probate work, I developed my own forms simply because it's easier to have every form in one template to merge all the variable information. And so obviously you need to update those things as time goes on. But I just want to, so this is a little practice. This is you know, a little type-over form, as I call them. A second, one page at a time. And again, the purpose is the highlighted information is the variable information. And, you know, for most of these forms, if you did create your own set of template, the variables are, for the most part, are names, address, and phone numbers, and the name of the deceased, obviously. But, you know, these are some of the forms, the notice that can go out to interested parties that you're applying, the declaration of completion of training. Again, just names and addresses. The application is probably the most complex one, but still you're looking at names and addresses. You're looking at saying, you know, when the decedent died, what their age was, who the surviving spouse, children, devisees, heirs of the decedent are. And in probably most cases that I've been involved with, you know, there's often just a spouse or a child or two. You're saying whether or not 2 years, the time for informal probate. So this is an important issue. You must process an informal probate or initiate, I should say, an informal probate within 2 years of the date of the decedent's death. However, if more than 2 years has passed, you can still do an informal probate, but you are restricted as to how assets pass to the heirs. In other words, the assets can only pass to the rightful heirs. You can't sell them and divvy and then divvy it up from there. So for just by way of example, and this is going to be the most common thing, you know, if someone died, more than 2 years has passed since the date of the death, and you know, you have the situation is such that you have to do an informal probate, and you can. That even though 2 years have passed, the only difference really is that the transfer has to go directly to the heirs. So let's say that, you know, we have two children that are inheriting the assets. You can't just sell the property and divvy up the proceeds. It has to just be transferred to those heirs, and then they can do whatever they need to do. Anybody have any comments on that? Let me know if you think I'm not describing everything I should, but that's in its simplest form. But, you know, also, you know, let's say there's whatever $600,000 in a brokerage account, same kind of thing. It has to just go to the heirs. It is an abbreviated process as well. So you can go directly from applying, getting appointed, distributing the assets, and closing. Whereas normally there are other processes that you have to go through. But so again, I'm just kind of scrolling through this, showing, you know, how the simplicity. These are the testamentary letters. This is the most important document. I'll talk about processing in a second. The statement of appointment by the registrar appointing the person. This is for a testate probate, so with will. So all right, so I'm gonna go back to the
Don?
PowerPoint. Yes.
Also, for a tardy probate, I believe you do not have to publish a notice to creditors.
That's true. Yeah, that's why I'm saying you can go directly to that. But I'm going to go over how to process those things now. But thank you for mentioning that. But that's true. It can be a very abbreviated process. So how to process it? You prepare all the documents. You have the client sign the cover sheet, the application, the letters. You notarize all that. They sign the order to personal representative. You provide the certificates of completion for both the classes. If it's an intestate probate, each You have each interested party sign a waiver of bond, waiver renunciation of right to appointment, make at least one copy of everything and take it on down. You submit it to the clerk. The clerk will have you fill out a little form where you just kind of give them your contact information, and it takes recently in the last 2 years, I find that in Maricopa County the turnaround is like a day. And you'll get an email that says, yeah, it's accepted. You've got so much time to go pick up your approved documents, and at that time you get the certified copy of the letters, however many letters that you want. And by the way, the filing fee is $279, plus $30 for each certified copy of letters. And I've got a little practice tip there that, while the client will likely need a certified copy of the letters for each asset of the decedents, I don't know if I want to say it like that. What I'm trying to say is that, the client may want, let's say the client knows, yeah, the decedent had a bank account or bank accounts at Bank of America, had a brokerage account at Fidelity, has some real estate in Pinal County. So how many is everybody going to want to see a certified copy of the letters? Yes. However, some banks or brokerages may look at it, make a copy of it, and give it back to you. So you can reuse the same thing. So you're not spending, if you've got bank accounts at 7 different banks, you don't have to necessarily get 7 certified copies of the letters. So just a little practice tip. Yeah, and the other thing is you can always get more. All right, so how to process afterwards. Once somebody's appointed, you have to send a notice to all the interested parties that you've been appointed. You have to send a notice to creditors, to each creditor that is known that you've been appointed, and they have 4 months basically to make a claim against the estate. Whether or not they make a note, if there's a known creditor, you need to deal with them, or your client needs to. I will tell you that I've never taken that responsibility on. I always tell clients that I'm processing the paperwork, but if there's a creditor, that's something you have to deal with. And if you need advice on that, I would refer that out. But also, a notice to creditors has to be published in a newspaper of general circulation in the county where the probate's has been filed. I've always used the Arizona Capital Times. I forget what their fee is nowadays, but let's say it's $40 or $50 to publish for what is it, 3 consecutive weeks, I think it is. That's a critical thing to get done as soon as possible, because you cannot close a probate any sooner than 4 months from the date of the first publication. And so you want to get the notice to creditors published as soon as possible, and that gives unknown creditors up to 4 months from the date of the first publication to make a claim against the estate. The next process within, by the way, the notice of appointment, I think, is within 10 business days of the appointment, the notice that you have to send out to interested parties. The inventory and appraisement of estate assets is, again, simple document, basically says, and you can, for personal property items, I think you can combine things, but basically listing, here's what's in the estate. There's a, real estate located at, 3170 East Indian School Road that's, valued at, $400,000. That has a lien against it for X amount. There's also a bank account with $50,000 in it. There's a brokerage account with $10,000, so on and so on. That has to be prepared and mailed to the interested parties, and a proof of publication. Whenever you mail out something, that has to be a proof of mailing, I should say, or service, filed with the court. And then the client can engage in whatever it's going to take to administer the estate. So that might mean doing a deed of distribution, transferring real estate, for example, that's in the estate to whoever's supposed to inherit it, or selling the real estate out of the estate, however it is that they're going to administer the estate. And then when they're all done with that, when the requisite time has passed from the notice to creditors being published, they can close the estate, which is a simple document that says that we did all those things. So that's basically informal probate in a nutshell. Again, this is kind of an introductory to that process. But if you want to read more about it, I'd recommend looking at the statutes, and just reading the information that's available on the court website is very simple. I don't think this is rocket science for most people to start to offer these kind of services. Now, when would you have to do something that's a formal probate? I'm sure there's more reasons than this, but common reasons would be a simple thing like I don't have the original will. So if you don't have the original will, you need to get a judge to say, yeah, what I have, the copy I have is the will. And so that would be one type of formal probate that would be filed. In my experience, there is a hearing where that determination would be made. There used to be an ability to have a non-appearance hearing, but I don't think they do that anymore, the probate judges. But after that process has gone through and the person at that time, the judge would determine that this is the will, and this person is appointed as personal representative. The rest of the process is the same as what I just described. And then when that happens, usually a judge will do a minute entry order, kind of giving you the dates that you have to comply with all those things, but they're the same dates, for the most part as that I just went over. Or if there's no will involved, a judge has to determine who the personal representative is going to be and what the who the heirs are and what their percentage interests are in the estate. And then also in that circumstance, whether there's going to be a bond that has to be posted. And those kind of issues I've tried to stray away from, where there has to be a bond, because that can be a really complicated thing, and for an individual that's not represented by an attorney to obtain a bond. But we're kind of not gonna get into that in this type of presentation. All right, so. And I think one of the last things I wanted to reference is the special administrator. So what this is all about basically is that your client can, under some circumstances, apply for, kind of a limited appointment, a limited scope of authority over an estate if there's a kind of an urgent or emergency situation. So that would be used like if you need to get authority to do a funeral or to have somebody cremated, or there's something going on where you need to get emergency authority to protect the assets. I remember years ago I had a situation where I did this for somebody, and the circumstances were they had there were, this can happen with one kid, but I think there were like 13 children of this person, and two of them were just stripping the house. Not just taking the personal property, but literally stripping all the, everything out of the house, destroying the house. And so this person, which was one of the other kids, in agreement with the other 12 or 11 children, applied and was appointed and was able to take control of the assets to preserve them. But again, it's a process that is really surprisingly simple and straightforward, and I've never had anybody have a problem. I've had other situations too where having to do with funeral arrangements where children were disagreeing on what should be done. or just where there were some circumstances going on where the funeral home wanted this to be done, so they saw that they had authority to cremate a body, for example. And so this is a process that can be done to do that. I want to look at, I know there's some new messages. Oh, okay. So Kathy, in a tardy probate, no need to notice creditors. Okay, I already saw that. All right. So other miscellaneous issues and procedures, proof of authority. Proof of authority is a simple document that's used when somebody had open probate in another state and they needed to deal with some assets that were in this state. And so they're filing this proof that they have the authority to administer the state and get a local, case number. And obviously, along with that, they're going to be submitting certified copies of their letters, testamentary letters from that other state, and the order appointing them, and then they can administer whatever needs to be administered in this state. And I'll send you all, I think I have a copy of a proof of authority that I've used in the past that you can reference. Tardy probate we talked about. Joint probate we kind of talked about, where there's just some circumstance that would be more economically feasible or prudent to do a joint probate of a husband and wife, or circumstances where you probably, this is probably obvious, but you can have co-personal representatives. There can be issues with those. I never had this happen again, but the very first probate I ever did there were co-personal representatives. These were children of the deceased. Immediately after being appointed, one of them took off with like $40,000 out of the bank. But it can be dangerous for people to do that. But I certainly understand why people do that. Anyways, you can have co-personal representative. Living trust related issues, just to know that, in some circumstances you may file a probate like procedure having to do with a living trust. Like, let's say the named successor trustees are not alive anymore. And so, or you just have some disputed issue in a trust that the probate court might be willing to resolve. And the probate court is where you would typically go to do that. Okay, any questions, comments? All right, good. And thank you everybody for your comments in the chat and otherwise. So, all right, as I said, I wasn't too worried about taking a little longer with this segment because Carol really did a great job with her presentation. I think in the second part of her presentation that qualifies as, in ethics, a lot of it qualifies under ethics. So we're going to spend the rest of our time going over my ethics portion. And I think I need a drink of water to clear my throat a little bit, and we'll get into that. Okay, so let's talk about ethics. So the objectives in this part of the presentation are, we're going to go over a definition of ethics. We're going to go over briefly our CLDP roles and responsibilities. Angelica, did you have a question or a comment? Yeah, unmute yourself. There you go.
Yes, I have a question. Yeah,
go ahead.
I'm going to try to explain. Okay, I had a client whose husband died, and the guy left a house with a mortgage. So the equity is less than $75,000. In this case, the client have to go through probate or no?
Well, no, they could potentially do a small estate transfer affidavit, as long as the equity is under $100,000 and 6 months has passed since the date of death.
Oh, okay. Thank you. Thank you.
Okay, all right. And that's some of the, I'm going to send you all out, some of those, that affidavit and more information on that.
Thank you. Thank you.
No problem. Okay, so again, we're going to talk about CLDP roles. We're going to talk about when should an LDP maybe worry about a complaint being filed against them. We'll talk briefly about the complaint process, and then I'm going to briefly go over also some steps that CLDPs may be able to do to kind of protect yourself. I think Carol went over some of those possibilities as well in her presentation. So let's talk about ethics. So, just a brief definition. I'm sure we could have a 12-hour class on the, the moral principles behind how ethics are established or where they come from, if they come from man or God or both. But it's generally speaking, it's a system of moral principles adopted by individuals or maybe a group that pertains to the beliefs we hold about what constitutes right conduct. It affects how people make decisions and lead their lives and run their businesses. Ethical conduct covers dilemmas concerning kind of how to live a good life, our rights and responsibilities in life, and in our various roles in life, including our professional life, the language of right and wrong and moral decisions, what's good, what's bad. So when we talk about the law and ethics, ethical issues in legal document preparation are regulated by both law and whatever our professional standards are that we develop individually or kind of as a group. It's not uncommon for associations, for example, to have ethical standards or a code of conduct that may be considered to be a step above what even the government has as the minimal ethical code. So the law defines the minimum standards society will tolerate. These standards are enforced by the government, including our beloved Board of Legal Document Preparers. The minimal standards for the practice of a CLDP, as stated in our code, includes a code of conduct. So, all right. So now the LDP code, the purpose of the code really is that it recognizes the need to protect the public from the possible harm caused by non-lawyers who are providing legal services, and that has to be balanced against the public's need and desire for access to legal services. So, as all of us should be aware, what are our roles, what are our responsibilities, as a certified legal document preparer, we're authorized to prepare and provide legal documents without the supervision of an attorney for an entity or a member of the public in any legal matter. That's my favorite 4 words in all the code. When that entity or person is not represented by an attorney. And so now when we're doing so, we have to be preparing those documents and in compliance with our code of conduct, which would include things like the document being accurate in accordance with statutes and court rules. Herein lies a dilemma in some cases as it relates to things like citing court rules for motions, for example. So we have to prepare legal documents. We can prepare any legal document in any legal matter. However, when does the mere act of preparing that legal document conflict with the idea that we can't give legal advice? There's a legitimate issue there. So we can, as you all know, we can provide consumers with general legal information, but cannot provide any kind of specific advice, opinion, recommendation to a consumer about possible legal rights, remedies, defenses, options, or strategies. But we can provide general factual legal information pertaining to legal rights, procedures, or options available to a person in a legal matter when that person is not represented by an attorney. So we can talk to customers about what they could do, generally what people may do, but we cannot give specific advice about what they should do and why they should do that. And just roles and responsibilities include making legal forms from scratch and providing those documents, making them available to people who are not represented by an attorney. We can provide filing or arrange for services of the legal forms and documents. We can, when that person, again, is not represented by an attorney. So let's talk more specifically now, or somewhat specifically, about the Code of Conduct, LDP's Code of Conduct. So the role and responsibilities that we have must be offered and performed consistent with the Code of Conduct. And, and I cite where you can look at all the different provisions of a Code of Conduct. I am not going to go over every single one of those today, but I will touch on some highlights. Okay, so let's see. So I'm sorry, I lost my track of something for a second. Just a second. Okay, so, in considering our code of conduct, when could an LDP's acts or failure to act, for that matter, result in a complaint? And, the general answer to that is when the LDP's roles and responsibilities are not offered or performed consistent with the code of conduct. And there's, following the code of conduct, there are a list of grounds for discipline. So I'm going to talk now and kind of go through some of the major issues that can result in a complaint. So, some of those would be engaging in the unauthorized practice of law. Exhibiting gross negligence or incompetence in the performance of duties, aiding or assisting another person with acting as a CLDP who does not hold a certificate. So engaging in the unauthorized practice of law, I talked about that a little bit, going above and beyond what's described in our scope of services, telling people, specifically, what they can do, what they should do to, address, a specific matter. Exhibiting gross negligence or incompetence in the performance of duty, preparing things like, excluding or important elements, like if you're dealing with a civil matter, for example, excluding elements in a particular breach of contract case, or in a divorce, not addressing necessary elements of a divorce case, whether it be division of property and assets, whether it be calculating child support, or how parenting time or legal decision making is being proposed. Aiding or assisting another person in the act as a CLDP. I have a question for everybody. Do you if you have somebody working in your office that is not a trainee, is allowing that person to prepare documents in a certain way, or allowing that person to talk to your prospective or existing customers, is that assisting another person to act as a CLDP? What do you all think? Anybody? Yes. So Scott says yes. That's the question again was, if you have people working in your office that are not trainees, is allowing that person to assist you in preparing documents, or maybe on their own talk to people on the phone or in person, during whatever process that you're engaging in. Scott says yes, in that the person is engaging as a CLDP, but they're not a CLDP, so that's a problem. Okay, Carol thinks yes. How about a circumstance where you have maybe this person is a trainee, but you're not there? Angelica says no. Do you have to supervise? Do you have to review everything your trainee does? And Beth says not necessarily if I review the final information. Yeah, and I would say you have to be careful with that. Patricia says, I would say no if they're doing administrative tasks, intake, data entry, billing, phone calls. I would agree to that. But when does that cross over? For example, let's say you are engaged in divorce services and you have prepared all the divorce paperwork for someone, but you have your assistant who's not a trainee, not a CLDP, sit down with somebody and explain to them, this is what we're going to do. We're going to make copies of everything. We're going to take it down, file it with the court. After it's filed with the court, you need to arrange to have your ex-spouse to be come in and sign an acceptance of service. From that point on, we wait 64 days and then this happens, or 30 days, or whatever the case may be. Is that allowing your employee to act as a CLDP, essentially engaging in the unauthorized practice of law? These are ethical issues that we may struggle with sometimes. Or even with trainees, the amount of supervision that we provide or don't provide, I would say that it's not clearly talked about in the code. And I think there are things that we could question whether, is it okay for a trainee to prepare the documents as long as we are reviewing each of the documents? But then again, if you have a trainee, let's say, that doesn't have a college degree, so they're going through 2 years of being a trainee, is it, if they've prepared 75 divorces, at what point do we maybe have, is it okay in our judgment to not review every document that they prepared? Or do we always have to review it until such time that they are actually certified? I think these are fair questions. Okay, so kind of move on. Other grounds for discipline might be certainly engaging in habitual substance abuse. There are obviously other problems with that. Paying referral fees, whether the referrals from, let's say, accountants or CPAs or realtors or title companies, if we're giving kickbacks for things like that. Or does paying referral fees always mean paying money, or does it mean referring them back business? Those are important questions. Using deceptive advertising. So I'm being deceptive maybe about my skills, my experience, my credentials, the scope of what services I can offer. The classic, issue would be, let's say I'm a CLDP, but I did go to law school. Hanging my law school diploma, for people to see that come in my office, or maybe mentioning that on the advertising that I do, is that considered to be deceptive advertising? The one thing that I don't cite in this list that I have on here is engaging in the appearance of impropriety, which would certainly cover that in my opinion. But really thinking about the advertising that you do and whether it is deceptive or misrepresents your level of experience, the scope of your authority to practice, Those are things that we should always, think about and consider. Conspiring with other CLDPs to set prices. I don't know that I've ever been aware of that happening. But that would be a violation of the code, certainly grounds for discipline. Richard Hoyt is asking, can a notary open an office and use you didn't finish your thought, Richard. Can a notary open an office and use a something? So finish that thought, Richard.
Can they use a document? Can they use a document preparer to prepare documents under their business?
Well, I would say there are circumstances where a notary, you can have an owner of a CLDP business that is not a CLDP. But as long as you're following the requirements of the license, I guess that could happen.
Okay.
Does that make sense?
Yeah.
Yeah, and the notary company would need to be an LDP. It would need to be licensed as an LDP, and you'd need to have a qualifying person and to supervise.
Okay.
Performing work for a client when a conflict of interest exists. Let's see. I had an example, and I don't know what I did with that for that. But there can be conflicts of interest, and we should always consider conflicts of interest when especially when the client doesn't know about it. The classic ones that I'm sure we've talked about in the past, and these types of trainings would be where we did work for let's say a divorce for somebody, and then we had the adverse party come in at a later point, even if it's years later, to do some kind of an enforcement concerning the divorce, do some kind of modification, let's say to custody, visitation, or child support, or spousal support, whether it would be a conflict of interest to take that type of a job. And the issue is, do we have knowledge, private knowledge of that person? I'm not just talking about the examples I gave, but in any case, do we have knowledge about that person? Have we been a trusted person, involved in that with that person, that where it would be inappropriate to take on someone that has a conflicting interest? Or do we have a conflicting interest, just with that person? These are all things to consider when we're thinking about conflicts of interest. Failing to maintain client confidentiality, that's certainly a no-brainer. That would be a grounds for discipline. There are many more that we could talk about. So let's just get into the complaint process. Starting out with who can or should file a complaint against an LDP. The ACJA code states that all judicial officers, all court employees, certificate holders, including LDPs, and any person, those people shall. So if you become aware of an ethical, of a code violation or something that is listed as something that are grounds for discipline against an LDP, you shall file a complaint. And now any other person may notify the division staff if it appears the certificate holder has violated statutes, court rules, the ACJA, or or some related section. The division director of the AOC also may direct staff to investigate allegations of acts of misconduct or violations of statutes, court rules, or the ACJA, which may result in a complaint if the investigation, if such investigation protects and serves the best interest of the public. So, but again, bottom line, all of us, kind of, you could say we're kind of mandatory reporters. We shall file a complaint if we see that a violation exists. Now, how do you do that? Off the Arizona Supreme Court website, you can, they have an automated system where you can file the complaint directly online, or you can get the paper copy. This is what both of them look like. It's pretty basic information, just says who the licensee is licensed under, who you're filing that complaint about. And you provide your information. These are all the basic necessities of filing a complaint. You describe the allegations. It gives, and you have to sign it, date it, and tells you where to send it. And any, confidential information might be the complainant's information. So pretty simple. This talks about the complaint process, that there'll be an investigation, there'll be a probable cause review, and then it will eventually go to the board. And I'll talk about that a little more right now. So what does a complaint need to have? It has to be in writing, and it has to have sufficient information to warrant further investigation. So it doesn't have to prove that something happened, but it has to have sufficient information to warrant the investigation. It has to have specific allegations of acts of misconduct or violations of statutes, court rules, this section or the applicable section of the ACJA. A specific means clearly defined or identified in precise detail. Division staff shall recommend that the division director dismiss a complaint if it's not specific. Now, how does that? Well, I'll finish going through minimal requirements, and I'll comment about in my experience how that pans out. Other minimum requirements: you have to have the name, telephone number, and address of the complainant. Anonymous complaints are not accepted. Anybody here ever have an anonymous complaint? Okay, so I just wanted to comment that while, I appreciate this description of what it means to be specific, I don't know that I've seen complaints that didn't appear very specific. I'm not sure if that's, that issue has been litigated in our program about what that means. For example, I've seen complaints that simply said something like, I don't see how this person could have provided doc prep services without giving legal advice. So I guess what they're saying is they think they gave them legal advice, although there's not much in being specific other than the existence of the documents which we are legally allowed to prepare. But I've seen a few things like that. I mean, the bottom line is that, I think most complaints are going to be processed in some way. Director initiated complaints, division staff has to determine jurisdiction, so, if they have jurisdiction to look into a complaint, determine if there's sufficient information to permit investigation, verify details of the allegations, and have those details corroborated by independent observations, information, the allegations of acts of misconduct or violation of statute, court rules, or the ACJA. So there has to be some independent verification, presumably by the person that received this services or maybe was involved in the matter in some way. What won't get you out of a complaint? You can't get out of it by surrendering your certification. You can't get out of it by just allowing your license to expire. They're still going to follow through with the investigation and with the process if there's if there ends up being a finding of probable cause. Confidentially, the complaint is confidential until probable cause is determined. Except, the program can determine that certain information be released to like court staff, the attorney general, law enforcement, or other regulatory officials. If the director determines disclosures in the best interest of the public and the interest is not outweighed by other interests. So, reasons to dismiss a complaint. They might dismiss the complaint, certainly if it falls outside the court's jurisdiction, doesn't provide the name of the certificate holder on the complaint, doesn't contain sufficient information to permit an investigation. Again, I think it's a kind of a minimal, bar there to hurdle to show that. And I'm not saying that that's wrong. I'm just saying that I don't think it has to be too specific. Doesn't provide specific allegations of acts of misconduct or violations of the court rules. Contains allegations of acts of misconduct that, if true, would not constitute a violation of the statute, court rules, or applicable sections of the ACGAA. If there's no name of the complainant, that's grounds for dismissing. Or if it's just determined that there's no further investigation warranted. There's an investigation done. If any of you have been involved with this, that might include several things. Well, I guess I'll get into that in a minute. There's a notification to the certificate holder that you must come within 15 days of receiving the complaint, or within 15 days of that they received the complaint, they have to notify the certificate holder. And then the certificate holder in response has to prepare a written response to complaint. And that's due within 30 days of the notification. You can request an extension, and to my knowledge, the program can be I've heard of cases where they're pretty responsive to that and grant extensions if you simply ask for them if you need to. So the investigation that follows, there may be interviews of the certificate holder, the parties that are involved or affected. The CLDP may be sent a request for documents that might be kind of informal or formal, like the use, which may include the use of investigative subpoenas. There's a preparation of an investigation summary. I have a note to watch out for surprise facts and accusations of misconduct. Part of this process, which can be a little disturbing, is that sometimes I think they're out of the investigation will come allegations and issues about violations that were kind of not necessarily part of the original complaint. And I think there sometimes can be some due process issues with that. And so if you're involved with, if you have a complaint against you and you're involved in that, I would recommend that you try to do your best to make sure that you're going to get a copy of that summary before it just goes out to the board. Because what often happens is that the board will get that just a few days before the actual meeting of the board. And so you don't have a whole lot of time sometimes to review what's in it. So you can decide what action you may need to take. And whether that's appearing at the board when they're reviewing it or just doing something else. So there's a probable cause review, and upon completion of the investigation summary, findings by the probable cause evaluator and a written recommendation by the division director must be forwarded to the very next board meeting. So just to restate that, once the investigation is completed, they're required to forward that to the very next board meeting. And the board can review it and decide whether there's no violation, whether there is a violation, and what, that should warrant any disciplinary actions, which could be anything from a letter of concern to more of a formal procedure that, worst case scenario could result in emergency suspension or a revocation of your license in extreme situations, which has happened, although I don't think happens very often. So just we're almost out of time, and some quick notes on ways to protect yourself. Certainly having contracts with clients that clearly define what services that you're performing to them, for them, and I'll show you an example in a moment. Having a system in place with your practice about, that is more systematic in terms of the way you talk to your clients, from the initial screening to every description of the service that you're providing. If it's systematic, it's more, probably would be more likely you're going to be able to show that you're doing things appropriately. Whereas if you have no system in place and it's kind of random, it might be more difficult to do that. I have a comment there: the customer is always right. What I mean by that, and I'm not trying to conceal any violations or anything, but I'm just saying sometimes to avoid problems with things like the board or other types of complaints. A lot of people would argue that you get a complaint, give them their money back and be done with it, or whatever it is they're asking to do. I'm not saying this as a way of concealing something. I'm just saying that the customer is always right, and sometimes it's best to be done with it. Whereas giving resistance to a customer that just kind of wants out of a situation, maybe with you, can cause you a lot more problems than they're worth, even if you're right. So contacts with clients, and I'll send you this, with the PowerPoint. I think it's always good to have something that could, certainly that you have to disclose your authority in writing, and maybe having a detailed contract about what you're doing for them is a very good idea. Having systems in your phone consultation, your fee quotes, your schedules, using questionnaires to gather information from clients for various services is a good idea, so you can prove what information they gave to you and what they directed you to do. Keeping your completion guidelines, reviewing your procedures with them, or procedures in whatever process you're engaging with them. Document approvals. I don't know that many people use these, but when you're done preparing a document for somebody, in addition to having them review it, have them sign a document that just says, yeah, I reviewed it and I approve it the way it is, even if it differs from previous information that I've given you. And that just, again, another way of CYA. To have regular communication. There's a copy of a document approval people may use. Any questions, comments? I appreciate everybody listening and participating in the comments that they've made. Now I have one more, the final verification word that I'm going to hold up right now. But again, before I do that, anybody have any questions, comments about the last two presentations? Okay. All right. So the last verification word is straw, STRAW, straw. So you want to write that down along with the previous two words. Hopefully you got those, and you want to send those 3 words to me at the end of the webinar, and I will respond in the next couple days with your certificate of completion, along with the PowerPoint presentations and other handouts that were part of this webinar. Okay. All right. Anybody have any other questions or concerns or just announcements? Judy, you have your hand up. Go ahead. No. Okay. Well, if anybody have a question or comment, raise their hand. Christian, you have your hand up as well. Okay, I'm not sure if you have your hand up for another purpose, but if there's no other questions or comments, and I'll hang out here for a little while if anybody needs to chat. But please go ahead and raise your hand to say something. Otherwise, that will complete our AAIP continuing education for February, and I'll have announcements soon about another one in at the end of March and in April, which I anticipate at least the April one will be in person, maybe both. So thank you for attending. That's it.